Start. Para. In this application filed under section 482 of the Code of Criminal Procedure 1973, the petitioner has prayed for quashing the special criminal case number 25 of 2022 dated 2/8/2022 filed for the commission of an offence under section 18 (C) punishable under section 72B (2) of the Drugs and Cosmetics Act 1940 and the rules thereunder. Para. The complaint was filed against the applicant by the drug inspector on the allegation that the drug inspector had received information that the applicant was indulging in a sale of medicine to the patient without any license. The applicant is a medical practitioner. He is a psychiatrist. Therefore, a dummy patient was sent to the clinic. The said patient was examined by the applicant. The applicant then prescribed the medicines and sold him the medicines available with him under the bill. In short, it is the case of the respondent that the stock and sale of the medicines by the applicant to the patient was in contravention of provisions of section 18 (C) of the Act of 1940. The complaint was filed before the special court. Accordingly, the learned sessions judge issued the notice against the present applicant. Para. In this application, it is the case of the applicant that he is a registered medical practitioner. Section 18 (C) is a part of Chapter 4 of the Act of 1940. As per the Drug Rules 1945, more particularly Rule 123, the drugs specified in Schedule K are exempted from the operation of Chapter 4 of the Act of 1940. It is stated that the case of the applicant is governed by Schedule K, clause (5) and read with Rule 123 of the Drugs Rules 1945. According to the applicant, the entire stock was duly accounted for at the time of the inspection itself. The report of the analyst shows that the drug was of standard quality. In other words, it was not a spurious drug. The applicant has contended that his case squarely falls under Rule 123 of the Rules of 1945. Read with Schedule K, Clause 5. Para. The state has opposed the application. It is contended that the drug was stocked for the purpose of sale. The provisions of Rule 123 of the Rules of 1945, read with Schedule K, Clause 5, are not applicable to the case of the applicant. It is contended that the applicant was not supposed to maintain the stock and sell drugs out of the stock to his patient. Learned advocate for the applicant has relied upon the following two decisions to make good his submission that the case of the applicant is covered under Rule 123, read with Schedule K, and therefore the prosecution lodged against him was without any basis. In these decisions, it is held that the exemption provided by Rule 123 is to the registered medical practitioner. If the drug is provided by the medical practitioner which is exempted under Rule 123, read with Schedule K, then the offence under Section 18 (C) of the Act of 1940 will not get attracted. Para. Undisputedly, The applicant is a registered practitioner. He is a psychiatrist. The drug inspector had sent a dummy patient to the applicant for examination so as to get confirmation of the information that the applicant was selling the drug to the patients without any license. The patient was examined by the applicant. The prescription is part of the record. The medicine prescribed was provided by the doctor to the patient under the bill. The inspector, after the raid, called upon the applicant to produce the documents to account for the stock of medicines maintained by him. Stop.